All right, it looks like we're right on 2 o'clock here. So I'm just going to do this intro, and if people are still coming in, that's totally fine. So I just want to let everyone know, thank you for joining us today. My name is Jay Fortune. I'm the office manager here at Standpoint. My role today is going to be to help facilitate the webinar. So if you have any questions during the presentation, please type your questions into the Q&A tab, or you can use the chat box as well. And I'll pass the question along to the presenters today if they haven't seen it in there. Most of you probably know a little bit about our organization, but for those that listen to this later via YouTube or those who aren't as familiar, our Standpoint is a statewide organization, a team of attorneys and advocates working to assist individuals who have experienced domestic violence, sexual violence, and trafficking when it includes domestic or sexual violence. We also provide assistance to system professionals who work with survivors. We do this by facilitating trainings and answering calls on our action line. Examples of trainings we have are our annual new laws that we travel throughout the state of Minnesota, or if you attended this year, it was virtual. Our monthly webinars for advocates such as this one, and other trainings by request. Our action line is answered Monday through Friday from 9 a.m. to 4 p.m. It is through our action line that our attorneys provide legal advice to survivors, and our advocates connect callers with resources, help safety plan, and listen and help callers identify possible options and next steps. This webinar is being recorded, and you can check it out on Standpoint's YouTube page. The link for the recording will also be emailed out to our Standpoint Legal Advocates listserv after the webinar. For today's presentation, I will be sharing a chat box link to the PowerPoint, so you can kind of follow along as we go along. Now, today I'm going to introduce our two presenters that we have today from Standpoint. Beth Assell is a staff attorney at Standpoint who joined the team in October. Beth graduated from law school at Hamline University and directly after graduation clerked in juvenile court in Hennepin County. Most recently, she worked as a staff attorney at Central Minnesota Legal Services for 6 years. At CMLS, Beth provided direct representation and legal advice in the fields of family law, orders for protection, harassment, restraining orders, and criminal expungement. She also partnered with the Domestic Abuse Service Center to represent victims of sexual and domestic violence and strengthen the capacity of advocates working in those fields. Beth previously worked as a full-time volunteer with Lutheran Volunteer Corps and AmeriCorps, and brings to Standpoint a lifelong passion for advocacy and helping others. Nikki Kelly is our legal advocate here at Standpoint. She has worked with in the sexual and domestic violence advocacy field since 2012 with experience providing crisis intervention, safety planning, medical and legal advocacy, and other supportive services to victims, survivors from a variety of demographic populations. Nikki has also has experience coordinating multidisciplinary teams, developing programs, and training advocates. Prior to her advocacy work, Nikki served in the U.S. Air Force. She graduated from Argosy University, majoring in psychology, and holds a Master of Science degree in forensic psychology with specializations in victimology, family violence, and sex offender behavior and treatment from Walden University. Nikki is also a member of both the Salute and the Psi Chi Honor Societies. So I'm going to pass the mic off to Nikki and Beth, and they can get started on their presentation today.
Thank you so much, Jay. Really appreciate that introduction. As Jay said, I'm Beth. I'm one of the staff attorneys here, and Nikki and I are so happy that everyone's joining us to talk about remote court hearings and tips for advocates on how to best navigate this new world. As Jay said, just want to emphasize that Nikki and I are planning on doing a lot of talking, but we would really like to hear from you all if you have any questions that pop up. So please don't hesitate to put things in the chat or the Q&A function, and we will do our best to address those questions, excuse me. So I'm going to give an overview of what we're talking about today. Just a note that we're giving obviously a webinar and remote hearing. So any errors that you see today, any errors that Nikki and I do, like technology fails or flubbing our words, completely on purpose. We're showing you what can go wrong and how to address it. So just to note that up front. So today we're hoping to cover some general court procedures, gaining access to hearings, etiquette for remote hearings, special considerations during remote hearings, such as interpreter participation, and then with a little bit of a focus on OFP, so order for protection, and HRO, harassment restraining order hearings, because we know that Our advocates do focus on those a lot, preparing victim survivors, submitting evidence for remote hearings, submitting objections during those hearings, and witness testimony, and then also ending with a little section on when it goes wrong, because it likely will, and it likely has already during one of your hearings. Okay, so just some disclaimers up front. Standpoints, so the organization that Nikki and I work for, we're not affiliated with Zoom or other programs mentioned in this presentation. Advocates may have noticed that across counties and sometimes even within the same county, courts don't have a standardized practice of how they're running these remote hearings. Their practices may vary from what is discussed in this webinar, especially just highlighting that at this point, courts are using a few different platforms. Some examples you may have used to access hearings are WebEx, Zoom, and VMR. One note is that the courts are currently, from our understanding, are currently working on standardizing this as best as possible to have more of a unified practice across counties and even within counties. The general push right now is to use Zoom as the main platform. That's the one I'm most used to. It's probably, if you hear us refer to a platform during this or show functions, it'll be assuming that Zoom is being used, but those other platforms are still being used in some counties. And advocates are encouraged to review the guidelines found at the Minnesota Judicial Branch. They have a section on remote hearings, and thank you, we just have it in the chat box right there. And you can also contact your local court for any further guidance that may be specific to your district. Okay, we wanted to just start with a video from YouTube on the various things that can go wrong during remote hearings and work hearings. Might make you feel a little bit better about some of the hearings you've had, and then we can maybe touch on various mistakes that are made after this video.
My apologies for that. Okay, Jay, you may have to jump in here and remind me where that dialog box is at. I'm not seeing it.
It should be like a small check to include your audio when you go to share your screen. So I think you have to stop sharing and then come back in.
Okay, come on. All right, let's try this again. My apologies.
The question is, how do the democracies respond to those scandals?
And what will that mean for the wider region? I believe one of your children just walked in.
Okay, so the question then becomes, I apologize. Pardon me?
Ah, there's your nanny.
That's not my nanny, that's my wife.
Oh, goodness, sorry. One more time.
The question is, how do the democracies respond to those scandals?
And what will that mean for the wider region? I believe one of your children just walked in.
Okay, so the question then becomes, I apologize. Pardon me?
Ah, there's your nanny.
That's not my nanny, that's my wife. So the policy, South Korea's policy towards North
Technology kills viruses in just one. What did you do, Mom? Dad, holy crap! Ya quedó, ya solamente tenemos que registrar autonomía curricular y el área socioemocional de los niños, porque esa parte no está quedando bien. Perdón.
Their concern is that they want to have Kurdish. Excuse me, my kids are here, live television.
Is great for bringing about a sense of relaxation, well-being, and calm. So starting just quickly by breathing in and breathing out. And it's really challenging, I know, with children home from school and working from home, but just trying to just keep all of those distractions out of the way.
600,000 people applied yesterday, and that's, of course, only 1/4 of the total amount of people. And you just met Lulu.
I'm sorry, but I have to say, Glenn, that is fabulous. This is maybe the first cat sighting in all of the home offices across CTV. So.
Okay. She's friendly.
Another tough issue he wants lawmakers to address is liability. Excuse me. And come here. I need you to not be in my shot. Thank you. Can you sit?
Thursday morning, a bird just flew into my house. Well, that makes for good TV. Good morning, everyone. It's a crazy morning over here at my residence, but we have some cloudy skies over there.
Sorry about that.
Of picking up 2 to 3 inches of rain, some places even more.
Mostly sunny skies, so make sure you get outside if you can. It'll help all of our moves.
Yes. And it's down, okay? I love it. Hi, Bernie. These are the trials and tribulations of doing your forecast from home. Hello.
Okay, so as we saw, now there's a lot of things that can go wrong, even when we're trying to do a webinar that we've practiced quite a bit. So let's talk about some of the ways that we can avoid some of those faux pas. We can start with the remote access link and being able to just get into the court hearing. That's not always the easiest thing to do now that we're remote. So we might have to be creative in how we obtain that link. Sometimes you can go to the courthouse if it's available and get it off the public computer. Contacting court administration is an idea. If it's a criminal case, you can contact the victim witness coordinator if they have one, or the prosecutor's office. You can also get the link from the victim survivor. I know that there's some language in the form that they receive that gives them that access information that says they're not supposed to share it with anybody. The court does allow for an exception with advocates.
And one thing we just wanted to note for this section is that when it comes to accessing hearings, even though hearings are remote, they are still presumed public. Just like when you were in the courthouse and anyone could walk into the hearing, they are still presumed public. But participation or access, now that they are remote, may be limited by some tech restraints. So and we're saying as an advocate, you may go through all these routes to access the link, including from court administration or requesting it directly from the victim survivor. If your client would like a member of the public to attend, such as a support person, the best practice would be to contact the court well in advance to request to appear and request for a link to send to that support person. And advocates can help facilitate that decision. The decision officially on attendance is made by the presiding judge. And it may be, again, limited due to tech restraints and how many people can fit in the Zoom meeting. Again, there's no standardized practice on how many outside non-participants can appear. A general rule of thumb we've heard that maybe some judges are following is that the courts will limit the remote participation by members of the public to how many could fit in their courtroom if hearings were still occurring in a courtroom. So it's best practice, though, to not send that link out widely outside of between you and your client. What we're hearing from courts is that, and hopefully advocates are experiencing that, is that court administration has had no problem sending those links. Courts have had no problems with advocates attending, even for hearings that are non-domestic violence related. And again, we hope that's the case. You may find that other parties are not so respectful. They may pass out the link widely. It may be even easier than with in-person court to have many of their family and friends appear for support, which may seem intimidating to your client. May or may not happen, just something to keep in mind. And the court does have the ultimate decision on how many can appear in those presumptively public hearings. And again, they may try and limit it to the amount that could have fit in their courtroom.
So some thoughts that we have about that access, we also want to look at the logistics as well, or making sure that the victim survivor and yourself have adequate technology. It's a good idea to make sure that there's a strong enough internet speed. You can do that through Zoom. They offer a link to test your internet speed. There's other options as well. Certainly ask if there's an operable camera. If not, we'll talk about some of the options. If the answer to these questions are no, we'll talk about that in a couple slides about just some alternative ideas. Check your lighting and the background. A note about lighting, Beth has a window that's giving her great natural light, but if her camera was angled a little bit, that window could become extremely distracting. It could be this halo effect. Lighting right on somebody can wash you out. It could also from behind make you look like a black shadow like you see on news media, and those anonymous sources that they have sometimes, which could be something that the victim survivor wants. So I'm not saying it's a bad thing, but be cognizant of it. It may not necessarily be a good idea to be shadowed during an OFP or an HRO hearing. Some considerations about the background. We're going to talk in a little bit about how to put a virtual background in place, but it is something to be thoughtful about. We don't want the abuser figuring out a location if it's supposed to be safe. We want them to be thinking about some of those details in the background that you don't want to give away. If you as an advocate are joining a court hearing from your office, you need to make sure that the background is not revealing confidential files or information like that. So give some thought to what other people can see behind you. Also, make sure your devices are well charged, have backups available. Think about what happens when it goes wrong. What are you going to do? I'm also going to point out that communication offline, because we're going to talk about why you want that communication to be off the platform, that you have to be thoughtful about as well. If I'm sitting down here texting, the courts may perceive that, the other party may perceive that. It could become problematic. You need to be discreet with your communication. So we'll talk about some of the ways to make that happen. So if inadequate technology isn't available, or maybe it is available, but the victim survivor may not be particularly familiar with a particular form of technology, don't make assumptions. We want to start with a trauma-informed standpoint, and we don't want to assume that just because they're competent in one area means that they're comfortable in the other. So some options if they don't have technology. If you don't have technology, courts may have computers and tablets that you can use. The county law library might be able to facilitate access to a remote hearing, although I will note that many require an appointment to be made so that you can access that technology. There are some technology sharing options that you could consider as an advocacy agency if you have the ability to maybe loan technology to victim survivors or help provide that by having them join you in your office if it's safe. Those are certainly some viable options. You can explore community options as well, maybe connect with your local library, connect with schools, you know, any community action centers or other civic centers and things like that that could be helpful. And honestly, worst case scenario, if the victim survivor has a cell phone that is capable of joining, that's one option. And I do say that's kind of a last resort simply because there are limited functions with a cell phone access. It's not impossible, but as we're going to talk about it, there are certain confidentiality things that are not achievable with the cell phone.
And just for some examples in this slide, for example, I know Anoka County has offered tablets in their conference rooms for parties to use to appear for hearings remotely if they don't have their own technology. In Ramsey County, I've seen a list. It seems like they do a really good job of trying to make technology available. They've offered up their law library and various service centers, things like that, as different remote options. And we would say, again, cell phone, probably a last resort. It's not as good a quality. There's different functions you can't use, but I think the thing to emphasize to your client is the most important thing is for them to get themselves there. So if that's their only option, they should take it. But maybe as an advocate, you could check in with your court administration or local resources to see if there are other options your clients could take advantage of.
There was a question just in the chat box about is drinking coffee or water or things like that okay during Zoom court?
That's a good question. I would say we're going to have a slide on etiquette, but I don't think we covered beverages. So I appreciate this question. As much as you can, and as much as your clients can, treat your Zoom courtroom as you would in person. So think about, what would you bring into the courtroom? For me, I might, if I was in an in-person courtroom, discreetly bring in a bottle of water that I could seal and place it aside and take a drink when I need it. I have never brought coffee into a hearing, and so I likely would not do that during a Zoom court hearing as well. Nikki, do you have anything to add?
No, I was going to echo the same thing and say treat it like you would in-person court. All right, let's get some information from you, fabulous advocates, and that'll help us inform the rest of the presentation. So we'll start with our first question. Have you ever just practiced using Zoom or another remote platform?
All right, looks like we've got a good chunk of you that have voted already, about 81%, so I'm gonna stop the polling.
Excellent.
Great.
That's great.
That's really encouraging.
Yep.
All right, so we'd also like to know how would you rate your current skill level with remote meeting platforms? Do you feel you're a beginner, like you can successfully access and participate in one platform such as Zoom? You access this, well, we know everybody here is at least a beginner. Are you developing? Can you impress others by using uncommon features? Maybe intermediate, I can effectively use multiple remote meeting platforms. Maybe you're advanced, you can teach others to use a specific remote meeting platform, or you're a pro, you can teach people to use multiple remote platforms.
All right, it looks like we've got quite a few people that have voted, so I'm going to end the polling for this and share the results.
All right, so it looks like the majority of you feel that you're intermediate. You can use multiple platforms, but you're not at a stage where you feel like you could teach others. All right, one last one. All right, how often do you help victim survivors practice using remote meeting platforms? Say what? Never, but I provide resources regarding ways to practice upon request, or almost always.
All right, looks like most of y'all voted. I'm going to end the polling here.
That's interesting. You provide resources or you help them upon request, but you don't feel comfortable teaching. We're going to fix that.
Okay, that was our last poll question, right, Nikki?
Yes.
Okay. Oh, and Jay, I think before we move on, I think we had a question in the chat if our participants are muted. Are they muted? Are they able to speak up and ask a question?
Yeah, Susan actually wasn't sure if that was just kind of referencing the presentation today or just generally kind of in maybe Zoom court proceedings. So I don't know, Susan, maybe you can clarify.
Today. Okay, so during the presentation.
Yep, today everyone is muted, but if you, let's see, I think I could, if you wanted to kind of ask a question later in the presentation, I'm sure that'd be fine. We could invite you to unmute. And
okay, and then we also, okay, it'd be helpful to know about court hearings too. Sure, we'll go through that. And we also had a question about bringing a friend into a hearing with you. We can definitely touch on that during the etiquette slide. Okay, so we would like to suggest that as advocates, you could take a role in ensuring that you and the victim survivors, your client, are familiar with the technology by practicing with them ahead of time. If you don't have a Zoom account as an advocate, you can get one. And you can send practice links to your clients. You can invite them to a meeting, have them go through the process of signing on, and then going through a lot of the different, even kind of basic functions that they may need to get through the hearing and build up their confidence before doing so. Or you may find, again, no standardized practice that I'm aware of. You may even find that some courts send a practice link at least the day before so that you and your clients can practice accessing the hearings or remote platforms.
So one of the major reasons we would really encourage you to practice these things, and the next few slides are going to take you through these things as well so that you can take them and teach victim survivors how to use these. We really want to encourage you to do this because court is already stressful for your client. Court may be stressful for you if you haven't had a lot of experience with court. So let's take the stress out of this piece rather than adding an extra layer of stress. So let's talk about how to do some of these things. Ideally, we would love to see you practice it, but we can't do that with this format. So to join a remote hearing, we've talked about how you're going to get that link. There is that hyperlink at the top that says join Zoom meeting. I don't know if you can see my mouse.
I can.
Okay. Alternatively, if the link for some reason doesn't work, it should open a window and take you straight to the meeting. If, however, it doesn't work, you have the alternative option of this meeting ID and the passcode. So if you go to Zoom's webpage, say join a meeting, you would put that information in, you should be able to join.
Yeah, and one other thing I would note is that on one of the first slides, we included the link to the Minnesota Courts website for their remote hearings. In that, I do think it's a really handy guide that either for you as an advocate, or if you want to pass steps, there it is in the chat. If you want to pass steps on to your clients, they have step-by-step instructions on how to access the meeting in Zoom, VMR, and WebEx, so the 3 main platforms. So just in case, hopefully this link should work. I've definitely been in a situation where it hasn't, and you have to default to entering the meeting ID and passcode.
So once you do that, you should be able to access the Zoom link, and then you're going to have an extra step of figuring out how you're going to join that audio. You can, at the bottom of that pop-up box, set a default if you think that that's helpful. But just know that you'll have this choice to complete accessing. All right, so let's talk about turning the camera on and off, muting and unmuting. It's very simple. Your instructions will show up. Now, all of this is being used, or all of these screenshots are from a PC. Not all of these functions will be available on a phone. So if you enter a Zoom meeting through a cell phone, it will just show your phone number, and you're going to have difficulty doing some of these functions that we're going to talk about, especially changing your name. So it'll show up your phone number, which could be confidential. So that's something to consider, and we'll talk about that a little bit. But as far as starting, stopping video, that's just toggling the switches down here.
And I think you'll find in a court hearing that you and then your client and their separate computers are going to be for the most part, completely in charge of whether your video's on and whether you're muted or unmuted. So encourage your client to be very aware of that. I think it's best practice to be muted at all times, except for when you're speaking or when the court asks you a question. So it will be different from this presentation style. It'll be more where the parties have the ability to mute and unmute themselves, unless it goes wrong and the judge does, as the host, have the ability to take over and mute a participant at their discretion. Okay, go ahead, Nikki.
Okay, so another option to consider is changing the screen view. There's a variety of reasons you may want to do this or encourage the victim survivor to do this. Foremost is that maybe they don't want to see their abuser on camera. So one of the ways you can do it, in the upper right hand corner, there's usually 3 dots that you can click and change that way. And you can talk to them about what those different options look like. Another option is to pin your speaker. So you could pin the judge to the center, and that's the only person that you would have to see. That's the only person the victim survivor would see, even if they're not speaking. And that is done by going on that individual's screen, finding those 3 dots that pop up, and that drop-down menu where it says you can pin them. Now, changing the screen name. We've kind of talked about this a little bit. So you're going to have to find it in different locations. If you have it set up where you have the speakers off to the right side of your screen, that might be clicking on your video and getting that drop-down box. This one, it was a Zoom for myself, so I just had to click on video. And I found that it was a right name. It was a right click for me, so if it doesn't come up right away, you might have to do the right click instead of the left click on the mouse. And then a pop-up box should come up that gives you the option to change your name. Now, I am encouraging you to be thoughtful about that and to know how to do this. Make sure that clients know how to do this. We've heard of individuals that logged into a court hearing with their gamer tag that had a profane name in it, and they refused to change it because they simply didn't know how. We don't want to put victim survivors in a position of being discredited solely because they don't understand technology.
Right, or for example, I have logged into a meeting with my trivia team name still as my Zoom name. So it was handy for me to know how to quickly rename myself. And as advocates, you can feel free to identify yourself in the box however you would in court. So if the judge goes around in court and you are used to just introducing yourself by your first name, that can go in the box. If you introduce yourself as just an advocate, I would put that in your box and protect your identity as an advocate however you would if you were appearing in person.
All right, another helpful option is the raised hand option. If court makes that available, it's usually under the reactions. I do not encourage anybody to use the emojis, but the raise hand option is in that same menu area. That might be a way to politely get the court's attention or possibly raise an objection without being disruptive. And if you did use the raise hand option, it would look like this little hand that's trying to high five everybody in the upper left corner of the screen here. All right, so virtual background takes a couple extra steps. With the video on, you're going to select the menu and choose the virtual background selection from the menu. That'll give you a pop-up box. Now you may have to add a background there. There should be a plus button on the right. I have the speaker views in front of me, so I can't quite run the mouse over it, but you may have to add a virtual background, like this bookcase behind me. There are several that are available for free on the internet, and they work pretty well. You don't necessarily have to have a green screen, although a solid colored wall of some sort tends to work best if you have that background. It doesn't have to be white or green, just solid colored. And then you would click on the background that you want, and that would then apply it to your screen. Ta-da! Donut. You might want to consider encouraging victim survivors to use something like this, especially if they're in a location that they want to protect or secure. You may want to use it if you have items behind you that you don't want other people seeing. So just think about it in terms of safety, security, confidentiality.
We had a comment in the chat box too about just someone said that they use their organization name because the court asked them to do that, and the name was the same as the defendant's.
I see. Okay.
Yeah, I think that's a perfectly acceptable idea as well. Whatever, yeah, whatever works.
Okay. So
All
just and someone has accidentally logged in as Scooby-Doo. Been there. Just quickly rename yourself. So in etiquette there. Okay, and here's a question maybe Nikki, you'd be able to address. Some virtual backgrounds do not hold solidly. Is there a way to overcome this? So maybe does it kind of appear jiggly? I think I have seen that with virtual backgrounds.
Yeah, you're going to get kind of that cutout with that virtual background. It's not a perfect thing. Green screens are going to help with that, but not everybody has access to those.
Right.
You know, the best thing you could do is just find a place that's neutral wherever you're at and just use that neutral location.
I would agree with that. And if they're going to do a virtual background, that's definitely something to practice in advance and make sure you or your client, whoever is using it, has the bandwidth to support that.
Mm-hmm. And not to, promote Zoom too much, but they do have that free account where you can create a basic account for free and you can practice those things.
Okay, here's our slide trying to cover all the aspects of court etiquette, which there's quite a bit. So first is location. So Nikki already touched on quite a bit about keeping safety in mind when you're thinking about location and making sure it's confidential, doesn't disclose a victim survivor's whereabouts if that is an issue. Also just to think about not only about safety, but what's an effective location for you and your client to be in when you're conducting the hearing. I know that one piece of advice I have seen, not advice, guidance I've seen courts pretty uniformly give is to not conduct your hearing in a moving car. I think with these hearings being remote, it'll be especially tempting for everyone, clients, advocates, attorneys, to try and multitask more than we may for hearings where we would have to set aside time to go into a physical building and just sit there. Don't give in to that temptation. Make sure that you find a location that is not a moving car. I've definitely had clients go in a parked car. If that's your only option, take it. I think the thing here to emphasize is it may not be perfect, for your clients. Their lives may not allow for it to be perfect. Just do the best they can with these tips in mind.
I'm going to jump in and add, the other important thing about location. Recall that video that we saw at the beginning of this presentation. Pick a place that's going to be limited with distraction free, ideally, or at least limited in its distractions. Do what you can to pick a place that gives you that sense that you're doing something very formal. You are doing court. So ideally, not from a moving car, not from a bedroom lying on the bed. Treat this like you were in-person court and encourage clients to do the same.
And to the best they can to obtain childcare or make sure that children who are old enough to care for themselves are in a separate part of the home, and understand that they cannot interrupt this meeting, that pets are taken care of in a separate part of the home. Nikki knows I have a cat who likes to break in, and it's incredibly distracting. You don't want that. And we saw the videos we played that it doesn't help anything. It's not going to be fatal to anyone's hearing, but it certainly doesn't help, and it's distracting. And I would say, in addition to children and pets, also other adults in your house, encourage your clients to let them know that they are in court and that is a very important formal proceeding. I think I've heard horror stories about participants who are sitting on the couch next to someone who's napping when they're doing their hearing. Just that's not the best location. Or someone walking behind them in a towel. Again, it's not going to be fatal, but it's a distraction that should be avoided.
And just talking about setting clients up for success, setting yourself up for success, dress for the formality of court. As tempting as it is with all of us being remote to appear in court in our loungewear or our PJs, don't do it. You really want to put them in the best position possible. And you want to put yourself in the best position possible. So dress appropriately for court.
Right. The court can tell if you are in your pajamas or if you're poolside in a bathing suit. So please try to avoid that. And then even if you're dressed formally, you can notice that pattern stripes kind of jump around on the screen. It's just try to dress in solid colors, especially if you and your client are going to be on the screen for a long time, such as a trial. Just solid colors would be best. We would encourage advocates and they themselves, and also work with their clients to close all other applications on the laptop. So for instance, I've silenced my phone on the laptop, I've silenced our Slack, and I've shut down my email, because otherwise you will see pop-ups coming, which is not only distracting, is kind of akin to having your cell phone going off during an in-person hearing, but it also could potentially be some confidential information that you don't want the other party to see.
Even more so remotely, when you're in person court, yes, you're not going to speak unless you're called upon or it's your turn or it's appropriate to raise an objection. Remote hearing has only emphasized that even more. I don't try to jump in when Beth is talking, because then you won't hear either of us. It's not that I can outspeak her. So it's important to really stay quiet when you're on remote hearing platforms. As far as the camera adding facial expressions, I really want to note that does emphasize things. You have this camera right up in your face. That can be a good thing. It helps the judge maybe see the impact that something is having on a victim survivor. However, it can also be distracting if you're reacting to every single thing that the abuser is saying or doing, or if the abuser is reacting that way, they could potentially hurt their side of things. So keep that in mind, that while emotion is not prohibited, be cautious with it. The same as you would advise a victim survivor for in-person court. It's okay to cry, but let's not scream, rant, rave, or show a lot of emotion when the offender goes off the rails.
Or shake your head, mouth words when he's talking or she's talking. I know it's exactly. I know it's tempting, remote or in person, but just a reminder, as with any court, that for a lot of these hearings, the judges are making a credibility call, and things like that do not help. And as Nikki emphasized, the camera can, if it pans to you because you're the one making noise or whatever it may be, the judge will see that up close and personal. And then I think the question we had on this page, Nikki, was clients bringing a friend to a hearing. So touched on that really briefly. I'm happy to again. So when you were going to in-person court, it was common, at least for me, for clients to bring a support person. To me, that is still an option. Hearings are still presumptively public. Your clients still have a right to bring a support person. But again, that link that the court sends out on the court's website, they specifically encourage that is for participants only and not to pass out widely. The courts would like to discourage that. So it would be best practice, and advocates can help facilitate this, is ask your participant ahead of time if they want a support person, and then be that person to reach out to court administration and get the link for that support person well in advance. And again, they're presumptively public. There's a lot of room on Zoom, but the official court website says that it's the decision of the presiding judge who can attend.
We have another etiquette question here. Is it best practice to remain muted when we are not speaking, or are we supposed to stay unmuted during the hearing?
I would say best practice to mute yourself when you are not speaking. Just to make sure that, I think you'll find that if you're unmuted, what I see in meetings is that even if someone who's not the one speaking, but they're clearing their throat or doing something, the camera is going to shift to them. It's distracting. You might make more noises than you realize. It's best practice to be muted, and then unmute yourself when it's your turn, when it was your turn to speak. And you may find it's very common to start talking and find you're still on mute. Someone will let you know right away.
All right.
And then we just wanted to note for advocates, just really briefly, that the Minnesota Judicial Branch, again, that same website that we've shared a couple of times in the chat, on their best, there it is again, on their best practices for remote hearings, the court does offer and encourages people to share widely a handout on best practices for remote hearings. It's available in English, Hmong, Somali, and Spanish. So it's some of the same tips that Nikki and I went over, but in a nice condensed, illustrated format. And this was just to let advocates know that if you wanted to just have something easy to send out to clients to kind of give them those tips ahead of time, the courts do have this format available, and it can be shared. Okay, so we had a question if a client can have a support person with them in the same room during the hearing. Nikki, what do you think?
I think absolutely, as long as they're not going to be a witness, which we're going to talk about if potential witnesses are going to be sequestered. If they're strictly a support person, absolutely, you can have that. Treat it like in-person court. I mean, a lot of our clients bring support people to court with them. This isn't that much different.
Right, as long as the support people are reminded that if they were in in-person court, they would be seated in the back or off to the side, however the courtroom's arranged, and they would be expected to be silent during that hearing. They're not passing information to the participant. They're not thumbs upping, making faces. Same rules apply for them. But right, I'm with Nikki. I don't see, they have the same rights that they do with an in-person court. They should have the right to a support person with them in the same room, as long as that person's not a distraction. Okay, and we would encourage you to strongly advise your clients on a few things. One is that just as with in-person court, there's no recording of the proceedings, no screenshots. If you, in a lot of courthouses, at least the ones I'm used to, that's pretty pointedly noted around the courthouse that it is a crime to record court. So same thing. It could be more tempting now that clients, witnesses, support people are in the privacy of their home. to try and record, because it can be so easy on Zoom or with their own cell phone or take screenshots, please encourage them not to do so. There's no good that can come of that. If they need a record, they can go through the same procedure as with in-person court and request a transcript. And again, that's also true for witnesses and support people. So as advocates, if you're reaching out to those people and helping your client coordinate, having support people or witnesses, that can be a reminder. No recording, no screenshots. And for every person that's participating, unfortunately, one thing that has not changed is that you still have to be prepared for a wait. You still have to be prepared for a delay. And courts are handling things different ways, in my opinion. Sometimes you'll log on to Zoom and you'll see that you're in a waiting room. It might identify your judge and what time their calendar is and that they're in another hearing. Your client should be aware of that. I know that when I was practicing, it would be common to get kind of a panic text of, what does this mean? Are you in the same waiting room? So just maybe a note ahead of time that there could be that waiting room. It's just remote hearings haven't necessarily made hearings move any faster, or for judges to schedule things differently, they could still be running behind. So clients, support people, witnesses still need to be prepared for delays, or be prepared for a possible mass calendar. I have seen in other courts where it's just like with an order for protection, maybe you're used to where everyone's kind of in the courtroom at the same time. The judge calls the parties up one by one. I've also seen that happen on Zoom. So everyone's let into the Zoom hearing at one time. You'll see a bunch of names at the top that have nothing to do with you. That's not your hearing. People are there for a mass calendar. In that case, it's best practice to keep your video off and mute yourself until the court calls your case. Unmute, turn your video on, proceed with your hearing, and then shut down when you're done. Nikki, we've had a couple questions. So one is going back a little bit, is if the support person in the same room needs to check in. So in my experience with in-person court, if there was a support person, I've never seen the judge make them identify themselves or check in, because again, hearings are presumptively public. Anyone could walk in. So my thought would be no, unless the judge specifically asks if there's anyone in the room with you, and then you could just identify that there's a support person. Do you have any other thoughts, Nikki?
No, I think it's similar to in-person. I mean, the judge doesn't take roll call generally for in-person hearings. It's, if they're accessing the hearing from their own technology platforms or technology, they might get questioned about why they're there, and they could simply say, I'm here to support so-and-so, I'm a member of the public. But if they're in the same room, if you're physically located in the same room with the victim survivor, unless the judge directly asks somebody in the room, no, they don't need to be identified.
Right. And then
again, as long as their role is strictly support, if they're a witness, we're going to get to that part.
Sorry about that. And then we had a question. Have you seen any kind of consequences for people recording or acting unruly on Zoom, particularly for OFPs?
Yep, we're going to talk about those at the end.
I would say just for the recording piece, I haven't, just because it hasn't come up. I don't know if anyone who's taken a recording has necessarily advertised that. I would encourage, if you find out that a recording has been made, to let the judge in the case know. I think that's something that they should be informed of, just as you would with in-person court. And acting unruly on Zoom, yeah, we will touch on that a little bit at the end. Okay.
All right.
Okay, so what if private communication is needed? And we're referring to communication between you as an advocate and your client. So one thing we really wanted to emphasize for advocates is that the remote program chat features may not be confidential. So that would be, if we're focusing on Zoom, as we all know, we're using it. There's a chat function at the bottom, and you have the option to either chat all or to chat just one particular person. You can run down the list and just choose who you want to send a chat to. It is important to note that Zoom chat can become part of the transcript, of the court transcript after the fact. And so those communications would no longer be confidential. And not to mention, I think it's particularly easy to think you're just chatting one person, but maybe chat the whole room, or to chat the wrong person, like send a chat to the respondents instead of the petitioner, if your client's a petitioner. So I would say if your communication is going to be maybe one word, right? Right, Nikki, like something an advocate would say, like at the end, just a quick chat of great job. Maybe that's not the biggest deal, but if you're trying to actually have a conversation during the hearing, we would really encourage you not to use that chat function in Zoom or any other platform. We have a few alternative communication options that you can consider. One is that you or your client can request a breakout room. So I don't know how familiar people are with this on Zoom, but the judge has the option to send different groups of people who are in the hearing to a breakout room, which is just a confidential room. So you're still on the Zoom platform, but you're in a whole separate room. The court does have the ability to have recording of the breakout room either enabled or disabled. So there's definitely an option to have recording disabled so that it won't be recorded, won't be part of the transcript. It would just be important to verify that upfront before you're in the breakout room that the court is not recording it. Another option is called SIF. So that's what you see on your screen with the CYPH. This is something that we learned about from the Safety Net project of the National Network to End Domestic Violence. Through SIF, you are able to send a burner link through a private message, and then through that burner link, a new browser window opens. And the benefit of SIF over like a Zoom chat is that it's private, secure, and the chat disappears when the windows are closed, and there's no transcript. It's not accessible to the court, and it's end-to-end encrypted. So if SIF were an option, like if your participant asked for a chance, a break to speak with you because they needed private communication, all that you would be sending either through the chat function or maybe through an email would be a SIF burner link, and then your communication would move into SIF and be confidential. Otherwise, you can just kind of go old school, ask for a break to talk, turn off your cameras, mute yourself, pull out your cell phone and text or call. You know, whatever it may be to get through what your client needs in that moment to have a private chat with you. As Nikki brought up in the beginning, alternative communication may be perceived by other virtual participants, so be discreet. I would say during Nikki, would you agree that maybe for text, you could limit it to what you would write on a notepad during a hearing? So maybe just a quick text that says, breathe, or you're doing great. Yeah. That's something that's very limited and probably won't be distracting. If it needs to be a larger conversation, that's when you're going to want to ask for a break and take one of those three options. Or if you're in the same room, obviously, you can just mute and turn off your video and have a chat right there.
I do want to remind advocates, it's really important to remember our role. We're there as supports. We're not there as coaches. So with the availability of alternative communication mediums, it could be tempting to coach that victim survivor what to say, how to handle something. We really need to remember we can't do that. So just keep that in mind, that your communication, even though it's remote, still has to echo what it would be for in-person hearings. We still need to be advocates.
And that, yeah, and our special considerations, that was my first point. So thank you, Nikki. I would, yeah, just echo that. Even though it's remote and it's tempting to do all kinds of things differently, yeah, the role is to support and not coach. And I do think that coaching, even if it's meant to be helpful, could be distracting and could be picked up on by the judge. And that's what we're trying to avoid. Having the judge think that your client is texting during a hearing, getting some outside information. It could impact the hearing and how the judge perceives them and their credibility.
Could also impact your profession. You don't want to be accused of practicing law without a license. So be careful how you handle that.
There was a question here in the Q&A around the SIF platform, asking how one accesses it. Also, if you're using your phone for the Zoom hearing, is the phone able to make or take a phone call?
I know that for a phone, I'm going to answer that backwards. If you go to a breakout room, if you're accessing a Zoom hearing from your phone and you go to a breakout room, you can't re-enter the main hearing. You have to actually log out and then try to log back into the hearing in order to get to the main hearing. So I don't know if you can make a phone call. I would assume that because it's a different program, you should be able to minimize one program and open the other. I know I can minimize my Zoom. So I think it's possible. Again, something you might want to practice with.
Okay, and then for SIF, it's not something that I've personally used. We've just, again, had it recommended to us by that great program, but that program sent us a link, and when I click on the link that they sent, it sends me to SIF, so CYPH.app, and just APP. And when you open it up, it brings you right to this purple screen, and it says, send the link below to another user. When they open it, you'll be securely connected. So maybe something to experiment with if you think that would be a helpful function to use with your client. Okay, thank you, Jay. I see the link in the chat. That's awesome. Okay, so just a few other considerations we wanted to touch on briefly is that interpreters can be included, obviously, in remote hearings just as they can in person. So just a note, if you're not sure how that would work, is that if you're on Zoom, which again, it seems to be the most common and what courts are pushing for to be standardized, Zoom allows for either consecutive or simultaneous interpretation. My understanding is that the other platforms are consecutive only. So if you're in Zoom, it's possible that the court will have the interpreter toggle back and forth between channels to speak to the court, and then another channel to speak to the non-English speaker. So if there is an interpreter with that function, those using have to join through the web browser on a desktop, a laptop, or a smartphone. You can't access that separate language channel on either ITV or a phone, or if you're calling in. If you're calling in, the court would have to switch to consecutive interpretation. Just as with advocates, the court can put the interpreter and whoever's using the interpreter, such as the non-English speaker, in a breakout room. The advocate can be in that room as well. And just a reminder to advocates and clients, especially if your client's not the one using the interpreter, like it's the other party or a witness, that when there is an interpreter present, especially for these remote hearings, it's helpful to speak slowly and take breaks, and remind them that the court reporter, so the one taking down the transcript, trying to catch every word, and the interpreters can always interrupt and ask for a break and ask to repeat, and that's okay. And the last thing we wanted to note on this slide is something called the Legal Kiosk Project that may or may not be relevant to your clients, but kind of a neat resource if it is. It's an ongoing project with the Legal Services Coalition, and it's meant to help people access court forms or other court info. So they have two models. It's ongoing. Model A can connect users to civil legal information, self-help, and statewide intake for legal aid. And then they have this something called Model B, where if your client is working with legal aid, there's more resources for your client who is represented by legal aid. They can use these legal kiosks to meet with their attorney or appear virtually. So you may find that if your client's represented by an attorney, the attorney is going to take care of appearing in the office, things like that. But it's just a resource that's out there. If they're represented by legal aid, they can look into the Legal Kiosk Project. Okay, and then we have a question. Does the survivor have to ask for the advocate to join the breakout room? Yes, I would say that it would be the victim survivor who would be the one to speak up and ask for a break, specifically to consult with their advocate and ask that the two of them be put into a breakout room together. Nikki, do you have anything to add on that? Okay.
Yeah, I was going to say, it doesn't mean that you as an advocate can't chat that to the victim survivor and say, do you need this? Remind them that they have that option, but it's got to be their self-determined need.
There was also a comment we had before, kind of going off what you were talking about. It just said we had one advocate get in trouble because court didn't know they were there, but they also hadn't asked. I mean, you're kind of talking about revealing who might be in the room, or
Right. Nikki, what did you notice during court hearings when you were appearing remotely as an advocate? Did you speak up and identify yourself when the judge was taking roll call? Did you stay silent unless the judge asked you?
Oftentimes I have entered on my own, so I had the screen name that already identified me as my agency or advocate. If I was in the room with a client, I'd usually make sure that I was on camera, maybe sitting a little bit behind them so the judge could see that I was present, and then I'd move away after things got going.
Okay. And again, if it seems like that's going to be a concern, like the judge would be angry because someone's there that they don't recognize, you may want to go the route of asking court administration to send you the link for the hearing rather than your client, and then you're identifying that you're an advocate who will be appearing at this hearing. And from what we've heard, there's been no issue with court administration providing that link to advocates, and that's encouraged. Should we contact the court reporter when we arrive and identify that ourselves? For a remote hearing, I don't think there's necessarily a court reporter to identify yourself to. It might depend on the county. I would say just kind of do what we advise, which is identify yourself in your tag on Zoom or whatever platform you're using. And then sometimes you'll find that it might be a court reporter, it might be a clerk or someone from court admin, takes roll call at the beginning, just finds who's there. I think that would be a good time to identify yourself and just say appearing as an advocate, whatever it may be.
Yeah, that's been my experience, is that generally court administration, court clerks are identifying clients and basically checking them in for the calendar. So that's a great opportunity if you want to take on that task to contact court administration and say, hey, my client is here for this hearing as well as me.
Yep.
All right, should we go on, or do we have, I see some more flashes.
I don't see any other questions.
Okay.
I think we're ready.
So let's talk about more specifics about OFP HRO hearings. So those order for protection, those harassment restraining order hearings. Even though we're remote, parties still have rights and responsibilities. Two of the biggest ones, they've still got that right to request that break to consult with their attorney or their advocate. We've talked about that already a little bit. And parties still remain responsible for being prepared to present their case. Whether it's a first appearance or maybe they're going to have an evidentiary hearing right away, they need to be ready. Just because we're remote does not mean the case is going to be continued. So prior to that hearing, some of the steps that you as an advocate can take as you're helping your client get ready for this or helping your client prepare. Maybe when you're writing that petition, consider attaching some of the supporting documents to the petition. In my experience, it's been helpful to sometimes attach some very well-chosen, thoughtful documents, like maybe some text messages, some photos, maybe the most egregious exhibits. You don't necessarily need to send a novel over to the court with the petition, but some of those stronger pieces. Doing that, I've seen in my experience, can help deter the respondent from seeking a hearing. So it might avoid a hearing, whereas otherwise they may have asked for one. But I do really want to emphasize that you need to be extremely thoughtful about that. You need to have a long conversation with your client about the pros and cons of that, including that makes those pieces of evidence public because they are part of the petition. They're going to be attached to it. They're going to be public record. And also, one of the pros of that I want to mention is it does help with some of the service issues that we're going to talk in a moment about when it comes to evidence. If you're getting ready for a hearing and you have a lot of exhibits that maybe you want to submit, those have to be served in a certain way. this is one way around that if you can attach some of that to the petition. One of the other things you could do is help the petitioner register for e-service if they're pro se. That'll help with some of that service that we're going to talk about. Definitely go over those access and etiquette tips that we were just talking about earlier in this presentation. Practice screen sharing as well. As you saw, I struggled a little bit. If they have audio, make sure that they check the box down at the very bottom when they're beginning their screen share. That's going to take the audio that they're going to present and make it so that everybody can hear it.
Okay, it looks like we had a few. So someone was pointing out that there's new restrictions about having what is considered confidential. That is true. Like I know, for example, that now police reports are considered presumptively, when they're filed, they're presumptively public. So I think those are all, those new guidelines are just something to take into account. And you're always, just as an advocate, you're always going to be talking with your client about what is best to have in the petition, knowing that the petition is also a public document and will be served on the respondent. It says,
yeah.
And then we have a question, is on the e-service and filing the OFP, is there a section that allows you to attach additional information like text messages? I feel like you may just be able to attach that to the end of the petition, like if you were to scan it all in together. Do you have any other way, Nikki?
That's generally if I have things that I want to attach, I have to go old school. And, and I do say that with a little bit of mirth. Yeah, if you have things you want to attach, I found that I had to print it, attach it, scan it, and e-file it that way. It wasn't something I could do through the filing guide.
Yep. All right. Yes, and we are scheduled until 3:30, and it's already getting up there. So we'll try and move through the rest of this quickly. Yep.
All right. So some considerations about witnesses. We talked about that location. That same thing applies to witnesses. Make sure that they're prepared for all of the things we've discussed already about being prepared for delays. Make sure that they have the ability to access the court. Make sure they have the link. It may be important to practice with the witnesses as well. Don't make assumptions about their technology competency. Don't make assumptions that it won't get clouded by emotion. You know, just because people may be competent with technology, again, to be trauma informed, we want to make sure that we're taking down that barrier as much as we can and making this something that's more routine, maybe even muscle memory, if we can get it that commonplace. They have one less thing to worry about and they can focus on the actual court matter. Same goes for witnesses. So practice with them, review the basic trial practices, the personnel that could be in court, make sure that they're comfortable with how that hearing could look. And if the judge or the opposing party asks for witnesses to be sequestered, think about, think about what that could look like. You know, they might need to be in separate rooms. They might need to be at separate locations. Especially with children, you may need another adult to supervise the children if they're going to be a witness, and you need to think about how they're going to access the hearing if they have to be sequestered.
Great, and I'm sorry, please go ahead.
Sorry. You also have to think about some of that technology piece of it as well. You know, if you have 5 witnesses all in the same household, maybe in different rooms, accessing different ways, that's going to put a drain on the bandwidth. So you have to think that that may not give you the internet speed that you need in order to fully access court. I do have a pro tip on here that I want to share for both witnesses and petitioners or respondents. If you draft out notes about what you want to tell the court, put that in a Word document, and then you can minimize your Zoom screen. It doesn't have to take up the full screen. Put the Word document on the other half. You can read what you want to share, but you're still looking at the screen and it's not as distracting. You definitely appear more confident that way.
And the only other thing I would add for witnesses is just a reminder to them. They cannot record and they can't have private communications during that hearing. Even if it's possible during a remote hearing to be texting like the client, they should be reminded not to do so. Okay.
All right. Again, I cannot emphasize enough that, what we're talking about is more utopian, and some of our experiences, courts are definitely going to throw curveballs. They're going to vary in their practices. So one of the things that I would strongly encourage you to do, contact your court administration prior to really worrying about a hearing. Have a conversation with them about what their expectations are, how you might navigate some of these issues that we're raising, like submitting evidence. And what I have found to be really helpful is if you can go in with both questions and propose solutions. So take some of these tips that we're suggesting today, talk to your court administration and say, hey, what if we submit our evidence this way? Does that work for you? I mean, ultimately, court administration, the courts in general, they want it convenient, but they need to make sure that they're providing equal access to parties. And finally, be really discerning with regard to evidence. Maybe it's not necessary to bring in 50 text messages and 20 photos. Maybe being selective about what text messages you bring in is sufficient. You can have a long conversation with the client and talk to them about, can one or two of these things effectively communicate the point? Do we really need to have all of this context here? Be thoughtful about what you bring in. And the other thing I will add is you could potentially be strategic about it. Some of your items, some of your evidence could be saved for either a cross-examination or a rebuttal, so you wouldn't necessarily have to submit that right away.
And when it comes to submitting evidence, I would say, especially for a remote hearing, preparation is key. It's not always going to be possible with how fast these order for protections move and HROs move, but if at all possible, help your clients organize and scan exhibits in advance. Having the documents scanned in means that if you get to that first hearing, that first appearance, and it turns into an on-the-spot evidentiary hearing, so you're not going to be continued out, but that respondent chooses a hearing and the hearing happens, that you'll have the exhibits ready to go, which means that you can email them to the court and opposing counsel or opposing party on a moment's notice. Helps you and your client avoid panic and to practice our pro tip, which is do not hold items up to the camera. I would say that is your absolute last resort for sharing exhibits, because it's incredibly hard to read and to get your point across. Because these hearings are remote, obviously not everyone's in the same room. You can't just show up and pass out exhibits, count on the court reporter or court clerk to help you mark them. So for that reason, is why it's especially important to try and organize in advance. If we can go back one, Nikki, sorry. Even if you've never done one before, you may want to consider a witness and exhibit list just to help organize your exhibits. You can help your client put them in the general order that they want to present them. It's okay to go out of order, but it'll help everyone be more organized if they're in some kind of general order about how they think they're gonna address them during that hearing. And at the very least, a witness and exhibit list may be nice, obviously not necessary, but you can help your clients number the exhibits. That's just an easy way for everyone to know, especially since you're not in the same room, it's maybe harder to get on the same page, know what exhibit your client is referencing when they want to get their point across. And the court may have a trial order, may tell you exactly how to number exhibits and how to submit them. But if not, it may be a good rule of thumb that if your client's petitioner, start numbering your exhibits with 1. If your client's respondent, start numbering your exhibits with 100, so that there's no overlap with those numbers and no confusion about who's submitting an exhibit. There are examples of exhibits and witness lists on the Minnesota Court's website under the Get Forms in the Family Court tab. And you can just work with the client again to organize them, put them in a general order, and to encourage them to reference each exhibit by number as they're going through. Okay, we can move on to the next one.
There was a clarification question. Are you suggesting the exhibits be emailed ahead of time?
Yeah, so that is actually on this slide. So we're suggesting that there's a lot of options to send in exhibits. So I'll just tell you some default options. The very first thing is review any trial orders that are in effect. This will vary from county to county, judge to judge. But if you find yourself in a position where you go to a first appearance and the trial is set out, a judge may issue a trial order saying that parties have to submit exhibits in advance, exhibit lists, witness lists, study that, meet those deadlines, follow how the court is suggesting that you submit exhibits. For a first appearance, no, not necessarily. There's very likely not a chance to submit exhibits in advance. I think that would be where you would just work with your client to the best of your ability to get them organized, numbered, and scanned in so that you're ready to go for that first hearing if you need to be. Otherwise, the court's website's one, that guide for remote hearings that we've shared a few times. They have some default tips for how to get exhibits to the court. And at least what the courts are recommending on their website is that best practice would be to get exhibits exchanged and sent to the court 5 business days in advance, unless the court tells you otherwise. And some options would be to mail, fax, or email them to the court, place them in a physical drop box at the courthouse, or bring them in person to the court's public counter. Another option would be e-filing exhibits with the court in advance. It may be helpful. If there's an opposing counsel, you can also e-serve them at the same time because they should be signed up for e-service. But just a note that when you do e-file, this will become part of the court record. So basically the advice is just like everything else, there's no standard practice right now on submitting evidence. We're just giving you some options and tips for how to get organized and how you can get those exhibits to the court in advance.
My best advice, I'm sorry, talk to court admin in advance, find out what they're expecting, have a conversation with court because each court is going to expect it differently. So the best thing you can do is have that preemptory conversation.
Yes. And when it comes to scanning, if you don't have a scanner, if your client doesn't have a scanner, you can download a scanner on your cell phone. And if you, as an advocate, are assisting with service on the other party, if the court sets a deadline for serving the other party, as an advocate, you may be the one to email those exhibits. One thing that we would recommend is considering a dedicated email account for your agency for that exact purpose. We have heard from an advocate who is assisting with serving the other party with exhibits with a specific note that here's your exhibits, I'm not open for conversation. I don't want to talk about the case. And they would just get a bunch of communication back. If you have a dedicated email account, you can use that to meet your duty of serving the exhibits and then just have a bounce back message or an automatic reply that this email account's not monitored, you won't be responding, whatever it may be. Okay, we're ready for the next one. Another option is for you or your client to use the screen share option on Zoom to share exhibits. This can include video or audio exhibits. You may find this, of course, again, is court dependent, but if you're using video or audio files, the court may require you to have a transcript because the court reporter does not provide a transcript of your video or audio clip. So screen sharing is a really neat resource on Zoom to take advantage of in these times of remote hearings. Basically, you could have the scan of your exhibits up on your computer, and when you share your screen, just like Nikki's sharing her screen so we all see the PowerPoint, everyone will be able to see the exhibit that you're referring to. And you can also annotate, and Nikki's going to just do a quick demonstration of that. So as part of Zoom, you are able to highlight specific text or point out exactly what part of the text you're talking about. There you go. I think that can be a really useful tool. If you're in the same room, like in an in-person court, I think it's really easier to kind of just show what you're talking about. Everyone's on the same page. If you're remote, this is your way to do exactly that. Highlight the line that you want to talk about. Highlight the part of the police report you're on. Because if the court says, what line are we on? Instead of counting down 15, been there where everyone's on a different line, just use the annotation tool to highlight it. Nikki, do you have any other tips on annotation tools?
No, it's pretty simple to use. It's up in you have to be sharing your screen in order to have access to it. And then it's this annotate function right here. It gives you a drop-down menu that's fairly easy to use.
Okay, and I think our only other tip about screen sharing was just especially good time if your client's going to be doing that, if you're going to be doing that, make sure your desktop is cleared of all other applications so you don't accidentally share something confidential or have more up than you mean to. Okay, so just a really quick note about redaction. If you're sharing documents, if you're sending documents in advance, if you're sharing them, some information on it will be confidential. As we've talked about a little bit in the chat, there's new rules from the court about what's considered confidential. So if you're sharing it, make sure to redact on things like medical records or police reports. You may want to redact confidential address. If temporary child support's at issue and you're submitting tax statements or pay stubs, redact social security numbers, bank accounts, etc. And so we've provided a link here to the to a site, thank you, that has some tips for effective redaction. I think the main thing that we wanted to get across is that even if you feel like you've redacted something within a document, your document may still have metadata or hidden code. It can include anything that was in the file at any time, even if the text was deleted or changed, or even if the file was resaved. If you're just screen sharing, may not be a concern of metadata. You're just going to have to make sure that you are effectively blocking it out with whiteout, whatever it may be, consistently across the document. We have a note here that ink marking or semi-translucent tape may still be seen, or it may be enough for someone to assume what was hidden. If you're going to do that, practice screen sharing it, make sure nothing comes through. Otherwise, the link that we shared is from the U.S. Court of Appeals. It has some really good tips of how you, in a PDF or in a Word document, can take steps to have unrecoverable electronic redaction, so that those tech-savvy individuals won't be able to recover what you tried to cross out.
Yeah, redaction may not be as much of an issue if you're screen sharing, but certainly if the court is expecting victim survivors to send information prior to a hearing or as part of a hearing, this is where it really needs to be thoughtful. There are instructions on that link, so I would encourage everybody to take a look at it to make sure that that metadata is really taken care of and deleted.
Okay, so just some quick notes. It very well may be that you never have a client who raises an objection. It can be kind of an overwhelming thing to do. Just a note that with the nature of remote hearings, you especially don't want to be talking over each other because it's harder for the audio to pick up and the court reporter to speak up. If you anticipate having to make an objection, such as having a respondent who likes to go off the rails, it may be best up front to clarify with the judge how they would like objections to happen. Some may say that they can just unmute themselves and make that very brief objection and wait for the court to rule. Some may want you to use the raise hand function, and some may save objections for the end. It's just good to know that up front. And then also with remote hearings, it's not like in-person court where an order for protection is issued, the judge can print it out, have the respondent sign, everyone's served, it's ready to be effective and ready, that there's service on the record in case there's a violation. Some things to consider is the court can have the respondent sign what's called an acknowledgement to service or a waiver of personal service. So it's not them agreeing with the order, but it is them required to, in the order, sign this document sign and file in the court file, acknowledging that they received the order for protection. That's just as good for service. That may be especially helpful if the respondent is represented by counsel and the counsel can help facilitate that process. The judge can and should make service clear on the record, make it clear that there's an order issued, the respondent is on notice and served, and that the order will be routed to the sheriff's office for personal service. If that is the case, it may be smart to have the respondent, so encourage your client to ask the judge to have the respondent to verify his or her address on the record, especially if the address is unclear, so that there's no question of where that order should be routed for service, so there's no issues in getting it served. Okay. Yes, and we know it is 3:29 according to my clock. We're just finishing up. Apologize, this is going a little long, but feel free to leave if you have other things to do.
Absolutely, but you really want to stay for when we talk about when it all goes wrong. And it will. Anticipate that. If it can, it will. You know, for example, we've already kind of touched on, you know, what happens if you're questioned about your presence there. As advocates, there is a standing Supreme Court order that says we can be there. You might not need to remind the judge about that, but just know that, you know, if you get questioned about why are you here, you have that backing from the Supreme Court to be there, especially for public hearings, especially to support your clients during OFP and HRO hearings. So let's talk about maybe the petitioner for a restraining order receives an incorrect notice of the hearing or doesn't receive the notice and misses the hearing. What are some of the options? If it's an OFP or an HRO hearing, certainly you can help that individual communicate with the court about the problem to see what they're willing to do, but in all likelihood, you may have to restart the process. You may have to submit a new petition. Acknowledge what happened with the prior petition, acknowledge that, you know, you didn't receive notice of the hearing, and the court should take that into account, should issue a kind of a do-over. From the criminal court perspective, if a victim misses a criminal hearing, you certainly want to contact the victim witness coordinator, the prosecutor's office if they don't have a victim witness coordinator, and maybe even consider contacting court administration. Make sure that they have their correct contact information on file, and consider adding the advocate or consider adding you as a secondary contact so you have that as a backup. Unfortunately, if a victim misses a criminal hearing, the court is unlikely to go back and do a do-over there, but you certainly want to make sure that they don't miss any future hearings. And when technology fails, because we all know it's going to, right? What I would encourage everybody to do is have court administration's phone number ready to go prior to joining a hearing. Give it to the victim or the petitioner as well. That way, if technology fails, you can make that phone call very quickly. You have that information readily available. You make that phone call and make sure the court administration understands that you're having technical difficulties. You're not leaving just because you're infuriated with the judge's stupid decision. Same goes for the petitioner, victim, survivor, you know, your client. You want them to be able to communicate that they're having difficulties. Try to re-access while you're on the phone. Otherwise, that gives the judge the option to continue the hearing until you can get the technology issue corrected. And like we alluded to earlier, there's going to be opportunities for individuals to try to abuse the remote hearing process, just like they do in person. You know, we have opposing parties that like to come in and dominate the conversation, try to dominate the courtroom to make sure that they're heard. They might dominate communication or be abusive and inappropriate. Courts can sanction them just like they can in person. That might be muting an individual. You know, court administration can control that. They might kick a person out of the hearing, or they can pursue other sanctions. You know, you can still hold a person in contempt. You can still issue a warrant for their arrest. One of the things you as an advocate can do, if somebody is being abusive, inappropriate, otherwise unruly, maybe the court doesn't see it right away. Again, have court administration's number readily available. Contact them, let the court know. They can get a message to the judge and let the judge decide how to handle it.
Right, and I guess another thing to note is I've heard of a hearing where maybe the respondent wasn't saying anything, but they were abusing the chat function, essentially what we've encouraged everyone not to do, but they were just in the chat writing a book about the other party and how terrible they were. And I think in that case, just keep in mind that the judge may not be monitoring chat. They have a lot going on. They may not even notice chat. Like Nikki said, that can be a call to court administration to point that out. Otherwise, your client could be warned and advised in advance to feel empowered to speak up and point that out to the judge, just as they would if that were happening in person. And that should be addressed by the judge at that point with some of the consequences that Nikki has pointed out. And just something, no, it's just like with in-person court that judges handle it in different ways. Sometimes they let the respondent go off the rails and talk. And if that's the case, if the judge makes that decision that they're going to allow the respondent to talk, you can think of it as just as you would as in-person court, that respondent is showing the judge exactly how they are and exactly what kind of person they are. And it's not fun for anyone, but sometimes that is part of the process. But if they are doing things like abusing that chat function and the judge isn't noticing it, I would empower your clients to speak up and point that out.
Mm-hmm. And that's where the raise hand function could come in, or maybe unmuting. I mean, there are options to alert the court to what's happening.
Right.
You as the advocate could also take that role too.
Right.
All right. We made it.
I wanted to check in with Colleen. I know, Colleen, at one point you raised your hand. Did you still have a question, or was that in regards to your prior question? I just wondered if you could clarify if you're still on with us. But in the meantime, we did have a question. And again, I'm sorry if I know you were talking about e-service a little bit. Someone had asked in the Q&A to clarify what that e-service is.
Yeah, I'm sorry I didn't catch that Q&A before. I do see that now. So e-service is just electronic service. So the court, if a party has an attorney, the attorney, for example, is required to sign up for electronic filing. So everything they file is online. They scan it in, put it into the filing system, and they can submit it to the court, and anyone else signed up for electronic service. Pro se parties are not required to electronically file and electronically serve, so send notice through that electronic platform, but they absolutely can, and they may find it helpful. It's also a way for them, instead of waiting for mail to come to them from the court and wondering when they're going to get their order, if that court electronically serves, so e-serves that order, and they're signed up for electronic service, e-service, they're going to automatically get that document in their email. I think it would just be helping them sign up, and encouraging them to keep an eye on their email if they do not usually do so. Okay, I hope that answers the question. Okay, and Malia is pointing out very helpfully, thank you, that once they do sign up for e-service, they have to continue to e-file for the duration of the case. Okay, I appreciate that reminder. So it is kind of a big decision to make, that if they take the jump into e-filing, I think it can be very convenient. It takes a little bit to get used to, but it is something they would have to stick to for the duration of the case. Okay, were there any other questions?
I don't see any.
Yeah, me either. Okay. Oh, we do have a question. Can you clarify what the status is of service of an order to the respondent over Zoom? How is that registered? And then it just ends with we, unless there's part of that question I'm missing. So I know that if a respondent signed up for electronic service, or they have an attorney who is, the order could be electronically served on them. And then there's always a record through the electronic service of if it was officially served and when it was opened by that party. So the court will know that they've received it and opened it. I can see one issue being that when you're going to enforce an order, you want law enforcement to very easily see that that respondent has been served. That's why you would see with in-person court that even if they were there with an attorney who was e-served, they would still have the respondent sign that order. So I think they would still be served. The question would just be, does law enforcement know that they're served? Which is where it comes into effect that they could still be asked to sign that acknowledgement of service, or have the order routed to the sheriff for personal service, so the sheriff can submit an affidavit of service. Okay, I hope that helps.
Awesome. Well, I don't see any other further questions. Thank you so much for everyone for joining us today. I'm sorry we went a little bit over, but if anyone had to hop off, we can view it later on our YouTube. Thank you to Beth and Nikki so much for presenting today. Thank you.
Thank you so much, everyone, for coming. We appreciate it.